Hi, this is Brian Dolan with the law firm Pepper Hamilton. There have been a number of examples lately of the U.S. Justice Department investigating and prosecuting the food industry on their product safety measures. The latest examples making headlines include Chipotle Mexican Grill regarding an E. coli outbreak, Roos Foods regarding a listeria outbreak, and Blue Bell Creameries, also a listeria outbreak. Joining me today to discuss what is going on in the industry are two partners from Pepper Hamilton's food and beverage industry team, Chris Wasson and Yvonne McKenzie. Chris and Yvonne, thanks for joining us today.
Hi, good morning, Brian. Thank you very much. Glad to be here.
Great to be here. Thanks, Brian.
Chris, in your view, is Chipotle dealing with just an isolated incident, or should they be worried about broader problems?
Well, Brian, I think everybody will see in the recent media that the most current issue is the U.S. Attorney in the Central District of California, along with the FDA Criminal Investigations Office, issuing a subpoena and beginning an investigation into the E. coli outbreak there. But I think if you go back in the headlines, you'll see reference to other E. coli outbreaks in the northwestern states in Oregon, Washington. Also reference to norovirus outbreak in Boston, which people probably saw because it decimated the BC basketball team for a game or two. And then also a salmonella outbreak in the Minnesota area. So I think even though the recent headlines and the investigations seem to be focused in California, with that many different geographies in the headlines and really different food safety issues arising in each, some were suppliers, some involved the preparation of meat, some of the issues involved sick employees who probably shouldn't have been at work. And so when you sort of stack those things up, in my mind, it raises a concern about a systemic issue or failure of the food safety program, or at least something that the government or the FDA would want to look at on a broader basis than just an E. coli outbreak in California. And I look at sort of my experience in working on government investigations and other FDA-regulated products, and I've seen, for instance, in the pharmaceutical industry, an investigation start with one particular product for a company, yet once the government gets involved and gets documents and starts talking to witnesses, they start to see a pattern of a marketing program or a pricing problem, and it becomes broader than just one product. And we've seen the government broaden their investigations in that space to include all products under a marketing program or marketing policies and procedures that they think are not proper. So I could certainly see the investigation in California with FDA and the U.S. Attorney's Office turning into something broader.
Can such a breakdown in a company's food safety program lead to exposure in other areas?
Absolutely. As recently as this month, we've seen the shareholder action filed in the Southern District of New York against Chipotle, which is essentially the plaintiffs are claiming that the stock price of Chipotle was artificially inflated because they had professed to the public or touted that they had adequate food safety measures. And so the plaintiffs' class action lawyers on the security side are now seeing all of these headlines and saying, wait a minute, their food safety program isn't as represented, and that therefore the stock price was artificially inflated. Those types of suits are extremely expensive to defend and generally result in large exposures for companies. Not to mention the brand damage nationally to Chipotle. I mean, you just see it in the headlines all the time. Companies need to be concerned about that and their market share. And then also with these problems, the company has to make SEC disclosures. So that's another issue you have to worry about. So it's much broader than the investigation in California itself.
Also, when you have injured consumers, you invite product liability litigation or consumer protection claims by individuals who want their money back for the adulterated product. And litigating these cases can pose a massive expense.
Have you seen an increase in DOJ activity around food recalls?
Well, food recalls have certainly been in the headlines over the last couple of years, and it's likely we're only going to see those numbers grow as technology in food safety and detection continues to advance. And we've certainly seen an increase in action by the Department of Justice in connection with recalls over the last 10 years in the food industry, both in investigations of food manufacturers and in criminal prosecutions under the Federal Food, Drug, and Cosmetic Act, both of the company and its executives. Now, this act imposes criminal liability for, among other things, introduction of an adulterated or misbranded food into interstate commerce. The Act provides for both misdemeanor and felony charges, misdemeanors usually for first-time violations, felonies reserved for those repeat offenders or knowing violations. A few recent examples of DOJ activity around food recalls. Well, of course, there's the highly publicized prosecution of executives at the Peanut Corporation of America. Now, this case involved a massive recall of peanut products due to salmonella outbreaks, responsible for several deaths and hundreds of people falling ill. Now, the executives in that case, the Parnell brothers, were convicted of 70 felony violations of the Federal Food, Drug, and Cosmetic Act. One of those brothers, the former CEO, receiving 28 years in jail and the other receiving 20 years. The DOJ in that case was seeking life sentences. This is an extreme example, as the executives had knowledge that they were placing an adulterated product in the market, which explains why the government there was seeking felony charges. Now, I do want to note that executives do not always need knowledge or intent to be prosecuted under the Act. The Park Doctrine, also called the Responsible Corporate Officer Doctrine, provides that executives and corporate officials can be liable under the Act without proof of intent or even negligence, and in situations where they had no actual knowledge. Now, many factors go into the Department of Justice inquiry as to whether they're going to prosecute under this doctrine, including whether the violation harms the public and the seriousness of the violation. Now, take, for example, the prosecution of executives of Jensen Farms in connection with a recall of cantaloupes. Now, in that case, the cantaloupes produced by Jensen were recalled over a listeria outbreak. That outbreak killed 30 people and injured many more. There, the executives claimed they didn't have knowledge of the adulteration prior to the recall. The DOJ there pursued misdemeanor charges of adulteration under the Act, and the executives were sentenced to 5 years of probation, a lighter sentence there. And most recently, as you mentioned, we see the DOJ investigating Blue Bell, which has issued multiple recalls of their products over listeria concerns, and there have been 3 deaths and several hospitalizations over their product over multiple states. What the company knew and when is likely a focus of the DOJ inquiry there, so we need to stay tuned. But one thing's for certain, it's likely that we'll see this trend continue, as it's clear the Department of Justice is sending a message here that if you put an adulterated or misbranded food on the market with the potential to harm the public, you're going to be at risk for criminal prosecution.
Can you offer any suggestions on how to mitigate these risks?
Sure. Having a good compliance program in place to prevent or mitigate risk is crucial. And in our experience, it's a good idea to have companies allow outside counsel to review these policies as well. Chris and I have reviewed many compliance programs across numerous industries, including those regulated by the Food and Drug Administration. Now, once you have a good plan in place, it's important to evaluate whether those plans are actually working and whether they're being effectively implemented. And you have to do this frequently, because a good plan is only beneficial if you're adhering to it. And finally, making sure your employees are trained on these programs, they're tested, and they're retested to ensure they're following your compliance plans, and they know, importantly, why those plans are in place. This applies to all levels of employees. Management must show that these risks are taken seriously because, frankly, the risk is too great not to.
I agree completely, Yvonne, and I would just add, to your point on the compliance programs, now that the regulations promulgated under the Food Safety Modernization Act are starting to come online slowly, seems like it's taken forever, companies need to make sure they incorporate any of those new regulations into their compliance program. But I agree completely with your point.
Let me pose this question to both of you. What kind of sanctions are you seeing being leveled in the industry right now, and what can companies do, in your view, to reduce the risk of harsh penalties?
Well, clearly, Brian, there are significant sanctions involved in criminal prosecution. Of course, the potential for jail time, but also fines and penalties that can amount to millions of dollars. The prospect of corporate probation is another risk there. In the Peanut Corporation case, the company was banned from doing business with the federal government for a period of time, which is a significant concern. Chris, do you have anything you'd like to add?
Yeah, again, I would just, point out the new regulations and authority and power given to the FDA under the Food Safety Modernization Act. And we've seen this very recently. In March of 2014, the FDA took the authority given to it under those new regulations and suspended a food facility's registration where they found there was a reasonable probability of which the facility is or should be aware that exposure to food will cause serious adverse health consequences or death to humans or animals. So in one of the first exercises of that new authority, recently in March of 2014, the FDA shut down a facility of Roos Foods in Delaware. It's a cheese producer in Delaware, and has shut the facility down in March of 2014, and has been shut down since, making its finding under the new regulation. So I'd point that out as a new potential sanction or risk for companies as well.
Now, Chris, have you seen a situation where the DOJ has used multiple enforcement mechanisms against a single company matter?
Actually, very recently, Brian, yes. In fact, unfortunately, I have to mention Roos Foods again, because this month it was announced by the Department of Justice sort of a three-pronged enforcement against Roos Foods. One was the filing of a criminal information with a guilty plea. The second being a civil complaint for an injunction, along with a proposed consent decree for a permanent injunction. And in the third issue involving Roos Foods is the Department of Justice and its criminal information is seeking civil seizure of adulterated food products of Roos Foods. So sort of a three-pronged enforcement action, all being announced at the same time by the FDA against one company.
Now, unfortunately, we've run out of time today. Thanks to both of you for taking time out of your busy schedules to talk with us today.
Thank you, Brian.
Thanks, Brian.
And thank you to our listeners today for joining us. If anyone is interested in more information about Pepper's food and beverage industry team, feel free to visit our website at www.pepperlaw.com.